Hey guys, David Terrace here, head of the Federal Criminal Defense Practice at the Rawson Law Firm. We are here again today to talk about biggest news in federal criminal defense in the Department of Justice. The entire system is the Donald Trump indictment. He appeared for arraignment in Miami federal court. Now, very interesting hearing. At that hearing, he got his bond conditions, and the judge also asked the former president, as well as his counsel and the government, if they had had an opportunity to review the entire indictment. That's always going to be a question that is asked at an arraignment hearing, because you can only enter a plea of not guilty if you have reviewed the indictment. The judge also asked Donald Trump and his counsel if they wanted the indictment read aloud. It is a long indictment. It's an indictment that carries up to 400 years in prison, of course, related to the documents that they are alleging. The government is alleging that he concealed, that he obstructed justice, that he needed to return. It's a whole bunch of allegations related to these documents that we're not going to go into detail on all of those, but 400 years, a lot of time for this, and a pretty unprecedented prosecution in our nation's history. So his attorney said, no, we don't need the entire indictment read. That's usually always what we're going to do in federal court, because we've had an opportunity to review it. Entered pleas of not guilty on all counts. Always at arraignment, we're entering a plea of not guilty on all counts, regardless of whether our client might already intend to be cooperating or interested in a plea. Always a plea of not guilty, because we need to do what Mr. Trump did and his counsel did, which is to request all of the discovery and request that the judge enter what's called the standing discovery order. That kicks in something known as the government's Brady obligations. The Brady obligation is an obligation that the government has. They don't have to be told to do it. They have that obligation no matter what, whether a magistrate judge tells them or not. This obligation says that they must turn over all discovery, specifically all exculpatory information that they have in their possession, evidentiary matters, evidentiary documents related to the credibility of witnesses, to the presentation of evidence they would put on at trial, every single thing in their possession that could be good for Donald Trump and not good for our clients, or bad for them. It has to be turned over, and it has to be done within a certain time period. So the judge did enter the standing discovery order in his case. The next matter that they discussed was the bond. And former President Donald Trump received as lenient of a bond as you can ever get in federal court. It's a personal surety or an own recognizance bond. Not only that, but even the normal standard special conditions of a recognizance bond, where you essentially just sign. You don't have to even have co-signers. You just sign saying you'll appear at your court date. The special conditions, a majority of them were not required. Usually somebody is required to remain within the Southern District of Florida, which runs from Key West to Fort Pierce, and if they want to leave, they have to request permission. Not required here. He did not have to surrender any passports. There was even a long debate regarding whether or not he would be allowed to discuss his case with witnesses. Now, the transcript is very, very interesting. There was a good amount of discussion about that, because he is currently involved in a presidential campaign, even as he did immediately after his hearing, going to a restaurant in Miami and then having a press conference in New York. He's going to be talking about the case. That's what former President Trump is going to do. He is absolutely intending on making this a huge part of his campaign and letting the court of public opinion play this out. That may be a sound strategy as a criminal defense attorneys, and at our firm, even with a high-profile case, that can be very dangerous. Okay, somebody who is regularly giving statements about their case, these statements can absolutely be used against him. He's already made some representations that the government at least believes, and a lot of news articles are reporting, that seem to be misrepresentations regarding the law and the facts. But this is his plan, and it may not be a bad plan. I mean, he's gonna bear this thing out with the public involved and with his campaign involved. Next step is going to be for the judge who's going to be on the case officially. This was just a magistrate. Judge Eileen Cannon will send what's called a standard discovery procedure order and setting court dates, court scheduling order, where there's going to be a calendar call set, which is the first court date where the judge is going to require the parties to come in and announce whether they're ready for trial or not, depending on the amount of discovery that's going to be turned over here. They may very commonly request a continuance of the trial setting, but they are going to have to comply with these deadlines. So it's going to be really, really interesting to see how much former President Donald Trump decides to not speak about his case and how much he does decide to speak about it. Normally, as a defense attorney, as we said, the Fifth Amendment is the strongest thing we have, but he intends to fight this in the public and in the courtroom. So it's going to be an interesting defense strategy, and we really look forward to seeing what comes next, which is going to be the exchange of the discovery process and seeing what kind of motions and pre-file litigation occurs, and we will definitely keep you updated. Thanks.